So yes, today we are going to take one more related topic. It's on it's on contributory negligence. It's a very important topic in continuation of the discussion that we were having so far. So it's a very important topic, okay, because some of you had raised some questions yesterday very aptly, okay, and are related, with respect to this topic that we are going to discuss today. So contributory negligence, okay. So usually what happens is that in a suit, okay, the plaintiff, okay, would say that, well, the defendant was negligent, okay. Well, fine. Okay, so to that extent, we have discussed our topic so far. Okay, that the defendant is found, liable for negligence. However, it is very much possible that while the defendant was definitely defendant was negligent in the way he had acted, but at the same time, it is also possible that the plaintiff was also negligent in a certain way. Okay, so those with respect to the same matter, okay, it's not a different fact situation with respect to the same fact situation, same matter, that the plaintiff may also have been negligent. So if that's the case, we can roughly call it a case of contributory negligence. Contributory in the sense that it is not just the defendant who was negligent, but also the plaintiff. Okay, so it is negligence in not avoiding the consequences arising from the negligence of the defendant. Okay, when means and opportunities are afforded to do so. Okay, so we know that the defendant was negligent. Okay, but the plaintiff also had enough opportunity, okay, to avoid the consequences that arose from the negligence of the defendant. Okay, but the plaintiff, being negligent, did not did not do what was necessary to avoid such consequences. So that would be a case of contributory negligence. Okay, so it is said that non-exercise by the plaintiff of such ordinary care, diligence, and skill as would have avoided the consequences of the defendant's negligence. So yes, there was a duty on the part of defendant to show ordinary care, diligence, skill. Okay, but even the plaintiff could have exercised such ordinary care, diligence, and skill, okay, so as to avoid the consequence of defendant's negligence. Okay, if that's the case, then we call it a case of contributory negligence. Okay, so are you guys with me so far? It's very simple. Did you guys understand?
Yes, sir.
Okay.
Yes, sir.
So an example would be, so for example, the bus that you have boarded, okay, the driver of the bus was is driving the bus negligently, maybe over speeding and also veering to the wrong side of the road. Okay, but there is clear instruction to the passengers, okay, sitting by the window, not to put their arms out. Okay, but some passengers sitting there just waves his arm outside of the window, okay, while the bus driver was also driving negligently. And as a consequence, the plaintiff here, okay, who claims, makes claims as against the bus driver who was being negligent, okay, the plaintiff's act here, okay, the passenger is also negligent in a certain way. So suppose subsequently, because of this incident, the plaintiff suffers. Okay, suppose there was another oncoming car, okay, and hit the arms, one of the arms of the plaintiff, and he or she is injured as a consequence. So that this ultimate outcome is not just because of the negligent driving of the bus driver, but also because of the fact that the plaintiff kept his or her arms outside. Okay, but then this is insufficient description of the of what might happen. Okay, so all those detailed fact situations will be looked into by the judge, ultimately to decide. But in the light of what I just described to you, you see that the driver was obviously negligent for what had happened, but the passenger is also negligent for negligence on his part. So this would be a simple, very simple explanation of a case for contributory negligence. So it's essentially based on certain maxims that we discussed earlier. Okay, not exactly though, but roughly based on the maxim of volenti non fit injuria. You put yourself in the way of harm. Okay, now you cannot claim that you have suffered damages. Okay, and your action, okay, is the proximate cause for the outcome. Okay, it's based on the maxim injure non remota causa sed proxima spectatur. Okay, I'll just type it here. You know what volenti non fit injuria is. I'll just type this one here as well. So here the act of the negligent plaintiff is also the proximate cause, not remote cause for the ultimate harm that he or she has suffered. So yes, it has to be the plaintiff's action here has to be immediate and proximate, okay, cause for the damage. Okay, so if that's the case, then plaintiff's own negligence or want of care, caution, skill has ultimately led to the particular injury. Okay, so in such case there is no cause of action for the plaintiff, because plaintiff has also done something, okay, that led to the harm that the plaintiff has suffered. Okay, so that's essentially what this idea of contributory negligence is. Okay, so far I hope you understood what this idea is. Very simple, okay, very easily understandable. I have just shared a link with you guys. Okay, and if you go there, you will see that there's a case in which it was held that it was not a case of contributory negligence. Okay, and why is that? We have already discussed all the requirements of sorry, I can't let someone who's not using their university ID. So anyway, let's proceed to this case, okay, by the name Davis versus Munn. Okay, so if you look at the briefs here, you see, so Munn ran over and killed Davis's donkey, okay, when he was driving at a smartish pace, okay, down the road of his road in his carriage. The plaintiff mistakenly tied the donkey in such a way that it could wander on onto the road. So usually what they do is they tie the front two legs in certain way so that the donkey does not run, but just goes at a slow pace. But Munn, who was running, who was going faster, runs over the donkey, okay, Davis's donkey, and then ultimately the accident happens. Okay, now the question is, who is liable when the plaintiff contributes to the outcome? So what is plaintiff's contribution here? That plaintiff had mistakenly tied the legs of the donkey in such a way that it could only wander around. Okay. But the defendant had the last clear chance to avoid the injury. The defendant, okay, here, if he had, taken the care, okay, then could have avoided the injury. Okay, so would the doctrine of contributory negligence be, applicable here? It was held that no, it wasn't. Okay, the decision was found in favor of the plaintiff, despite the fact that the plaintiff had tied the legs of the donkey in certain ways so that it could only move at a certain pace. So what was the reason? The court limits the scope of contributory negligence defense. Okay, they state that Although the plaintiff was negligent, this negligence does not prohibit him from having a cause of action. Merely placing one's donkey on the road does not give the defendant permission to drive fast and run it over. The defendant had the last chance to prevent the injury. Remember this, okay? There is a doctrine known as the doctrine of last chance to prevent the injury, okay? So the defendant here, okay, who was running fast, okay, the defendant had the last chance to prevent the injury, and his negligence was more blameworthy more blameworthy because a non-negligent driver would not have killed the donkey despite the plaintiff negligence. Okay, so negligence on the part of the plaintiff in itself, okay, should not lead you to conclude that, well, that was the cause for the accident here, for the injury. Okay, so you also need to keep in mind another maxim that we just looked at. Okay, who had the last opportunity to avoid the accident? Okay, who had the last opportunity? So that's very important. Okay, so that's what was held. Okay, so it was decided a plaintiff still has the cause of action if it is defendant's negligence that ultimately the cause of injury. That is, if a non-negligent defendant would not have caused the injury despite plaintiff's negligence, then the plaintiff can successfully sue the defendant. So it's very simple. With respect to contributory negligence, you need to keep in mind this other, doctrine as well, known as the rule of last opportunity. So essentially, the question here is that who had the last chance? Okay, who had the last opportunity to avoid the disaster, to avoid the accident? Okay, that is very relevant in deciding the case. So are you guys with me so far? Do I make sense?
Yes.
Okay.
Yes, sir.
Okay.
Yes, sir.
Yes. Then so we'll look at certain aspects of this doctrine of contributory negligence. Okay, so the plaintiff will be able to recover for the negligence on the part of the defendant. That's what we studied. Okay, however, contributory negligence puts some limit on that. Okay, so plaintiff will not then be entitled to recover unless the plaintiff shows that that he might, by exercise of ordinary care, okay, the plaintiff here could have, by exercise of ordinary care, have avoided the consequences of defendant's negligence. Okay, so we know that the defendant is negligent, but if the plaintiff also could have, by exercising ordinary care, skill, diligence, have avoided the consequence of defendant's negligence, okay, then the plaintiff cannot recover. The second one is that the defendant could not have avoided the consequences of plaintiff's negligence by the exercise of ordinary care. Now, if the defendant had the opportunity to avoid that consequence, okay, by exercising ordinary care, okay, then plaintiff would have been liable. But if the defendant had the opportunity, then obviously the defendant would be liable, as we have just seen in the case of Davis versus Mann. Okay, so that's the rule of last opportunity. Which party had the last chance to avoid the disaster? If it was the plaintiff, well, you missed it. Well, if it is the defendant, well, then you are liable for it. Okay, so yeah, that's essentially what this this entire idea of contributory negligence is all about. So I'll share another case with you by the name Davis versus Swan Motor Company. These are some landmark cases and they should suffice. Any more detailed analysis you want to do, feel free to go and look for cases you will find. Okay, so in this particular case, it's a very tiny little factual description here. Okay, so Davis had been standing on the steps at the side of a dust lorry. Okay, so there's a dust lorry. Okay, and Davis is the person who was standing on the steps, okay, at the side of the dust lorry. So that act clearly tells you that this is a case of negligence on the part of Davis. Okay, so because he was standing in a very dangerous place. Okay, The lorry was traveling along a narrow road, okay, when a bus tried to pass the lorry, okay. So what happened, as you could probably guess, okay, from this fact, this person Davis was ultimately killed in that accident, okay. Now the court found that all three parties here were negligent, okay. All three parties here were negligent, okay. But what about Davis, okay? So it was held that Davis was himself 1/5 responsible for the damage because of his negligence in standing upon or being upon the side of the dust lorry. Now I said 1/5 here, okay. Earlier, this apportioning the responsibility, did not exist under the common law rule. So in England, they enacted this Law Reform Contributory Negligence Act, and under which it basically apportions who owes how much responsibility in case of contributory negligence. So in this particular case, for the act of Davis, okay, who, he himself was negligent, okay, so he was himself 1/5 responsible for, the accident. So it was said by Bucknell that when one is considering the question of contributory negligence, it is not necessarily necessary to show that the negligence constitute a breach of duty of the to the defendant. It is sufficient to show lack of reasonable care by the plaintiff for his own safety. So that clearly tells you that it is a case of contributory negligence. Okay. So we'll use one more case. Okay. It's by the name Butterfield versus Forrester. I will share the link with you just a second. Okay, it's by the name Butterfield versus Forrester. Okay, so let's look at the facts. Okay, skip the brief and all that. Okay, fact: the plaintiff was riding in town. Okay, and there was just enough light left to discern the obstruction within 100 yards. Okay. A witness testified that if the plaintiff had not been riding very hard, he might have observed and avoided the pole. Okay, so the plaintiff was riding in town very fast. Okay, and there was enough light. Okay, so that you could see that there was an obstruction 100 yards ahead of you. Okay, but witness said that the plaintiff was riding very hard. Okay. But had he not, he would have observed the pole and could have avoided the eventual accident. Okay, so the plaintiff here, the person who was riding, fast, sued the defendant for negligence. Okay, that is the obstruction. The trial court directed the jury that if the plaintiff was riding along the street extremely hard and without ordinary care, they should find the verdict for the defendant. Okay, so although the defendant had created the obstruction, it should be held in favor of the defendant because the plaintiff failed to exercise reasonable care. Okay, so yes, the jury accordingly returned the verdict for plaintiff, and then the plaintiff appealed. Okay, so the issue is plaintiff permitted to recover for injuries sustained by defendant's negligence. Okay, if the plaintiff was also negligent, it was basically the decision was held again, in favor of the plaintiff. Okay, so as you can see, who had the last opportunity here to avoid? Okay, although we know that the defendant, although the defendant here had created the obstruction, so it's a case of negligence, but here the plaintiff had the last opportunity, to avoid the collision, to avoid the accident, and hence it was held against the plaintiff. Okay, so that's that's what contributory negligence essentially means. Okay, now two more elements need to be looked at for us to have a complete understanding of what contributory negligence is essentially all about. Okay, it is that the direct and immediate cause of the accident is the defendant's fault. Okay, the direct and immediate cause of the accident is the defendant's fault. Okay, without it the accident could not have happened at all. Okay, then obviously it is definitely the defendant who would be responsible in such case. Okay, so the direct and immediate cause of the accident is the defendant's fault. If that's the case, okay, then obviously the defendant has to be held liable. So had it not been for the defendant's negligence here, the case would not, it would not have happened, the accident would not have happened. And then if there has been as much want of reasonable care on the part of plaintiff as on the part of the defendant, then the plaintiff cannot sue. Okay, however, despite the negligence of the defendant, okay, if the plaintiff had the opportunity, okay, to avoid it, if the plaintiff had exercised reasonable care, diligence, okay, then could have avoided the accident, then the plaintiff cannot sue. So that's the case of contributory negligence. Okay, now this is a very important idea that we have just discussed. Okay, it reduces, earlier under common law it would be that the defendant would not be liable if the plaintiff is found to have committed have been responsible for contributory negligence. However, as I told you, in the light of this act, now what they do, that is basically Law Reforms Contributory Negligence Act 1945, they apportion the responsibility based on who contributed how much, okay, to the accident that had happened. So yes, that's essentially what happens. Now with respect to this apportioning, okay, responsibility, that's the law that exists in England. Okay, but then what about in India? In India, which rule do we follow? Do we hold a person, if there is a case of contributory negligence, do we hold the person who's basically responsible for, the plaintiff who might be responsible for contributory negligence, to have no cause of action at all? Well, that's not the case. Although we do not have any legislation of the kind that we have just discussed, okay, as it is in England, in India, we essentially hold this English position with respect to contributory negligence, and as has been held in the particular case that I have just now shared with you. So yes, accordingly in India as well, we apportion the responsibilities accordingly. So I hope this is clear to you. Are you guys clear with respect to the question of apportionment? So in this particular case, okay, look at the case that I have shared. It's by the name Vidya Devi versus Madhya Pradesh State Transport Corporation. In this particular case, there was a collision between a bus and a motorcycle at a road intersection. Okay, when the bus was going on the main road and the motorcycle came from the side of the road, from the side road. The person riding the motorcycle was, as a result, killed. Okay. Now the widow of the person who has been killed, the motorcycle rider, okay, and children of the deceased, it was found that the bus driver was negligent in not having proper lookout while approaching the intersection. The bus driver could have done better, okay, could have avoided the collision if he had, looked out. And the deceased, the person who died, was negligent in driving at an excessive speed while coming from the side road to the intersection. Okay, so it was held that the negligence of both, due to the negligence of both, okay, the accident had happened. Okay, but the motorcyclist was far more to blame than the bus driver. Okay, the responsibility for negligence was therefore apportioned in proportion of 2/3 and 1/3. Okay, the claimants were in this view allowed damages to the extent of 1/3 of what they would have got had the deceased negligence not contributed to his death. So you see that in such a case, okay, it's not as if the plaintiff is completely denied remedy. The plaintiff gets the remedy to the extent that the other party is responsible, and the plaintiff loses the claim to the extent that he or she was responsible for the negligence. So it's a very simple calculation that the judges would do, and this is something that we have taken from this English legislation. Now, what about contributory negligence of children? Okay, what about that? Now you know that children do not have the same level of understanding as grown-up humans have. So what about those situations? Would children be held liable to the same extent as a grown-up person would be? Well, that's not the case. But let's not say that the children have complete leeway here from the legal perspective. No, that's not the case. However, generally what happens is that children are held to be less responsible. Okay, so if it is a case of negligence, okay, on the part of children, okay, if the same act was considered, had it been done by some grown-up person, okay, then would have been considered as negligent. But in case of children, it will not be a case of negligence. Okay, so we have a case by the name, Lynch versus Nardin. I'll type the name of the case. I'm not able to find a good link to this online. So in this particular case, the defendant left his cart, okay, very attractive cart, okay, and horse unattended in a street where some boys were playing. The plaintiff, a boy, was climbing into the cart, okay, as you would expect from children, okay, while another pulled the bridle. The horse moved on, and the plaintiff fell down under the wheel of the cart and was injured. The court held that the defendant, the person who had the who's the owner of the unattended cart, was held liable. Although you can clearly see in this particular case that the children were also responsible in a certain way, but because this is what you would expect the children to do, so law imposes greater responsibility on those who are capable of understanding. So that would be your grown-ups. So yes, so you need to keep this in mind. Okay, so if there is no allurement, so the cart here, okay, is clearly a case of allurement. You would expect children to get up and be mischievous. Okay, so if there is no allurement, no trap or dangerous object that requires additional care, the defendant will not be liable. But if it is a case of allurement, trap or a dangerous object that requires care, then the defendant will be held liable for not taking required care. Okay, so that's what happens in case of children. But it does not mean that in all cases, okay, the other party will be held liable. Okay, so you have to be very careful. You have to look at specific cases, okay, and then find out whether the children can be held liable, for contributory negligence or not. So yes, that's the rule, okay, with respect to contributory negligence. One more very important thing, okay, very important maxim that you probably have studied in your legal English already, okay, but it's very important for you, and it is it emerges, it's relevant with respect to the question of burden of proof. Okay, so who has the burden of proof in case of negligence? Okay, so for example, in case of negligence, the plaintiff would say that the defendant is negligent. Okay, well, plaintiff has to prove that. Okay, so the burden of proving the negligence usually in ordinary course would be on the plaintiff. The onus of proving negligence is on the plaintiff. But there might be certain situations, okay, where the burden of proof is shifted on the defendant to prove that, and now the defendant is to prove that the defendant is not, was not negligent. Okay, and this is essentially the maxim of res ipsa loquitur. Okay, have you heard of this maxim anywhere? Are you guys with me?
Yes, sir. The things.
Yes.
The clad preparation we did it.
Sorry? Oh, clad preparation. Yes. Then you probably also know of the famous cases here. One of the most important case is Municipal Corporation of Delhi versus Shubhagwanti. So this is a case you will remember for the rest of your life, okay? Even after, after a long time that you have studied this subject, you will remember. But these are very important cases, okay? So res ipsa loquitur, as you guys have rightly just told me, means that res means thing, okay? Ipsa itself, okay, loquitur, speaks for itself, okay, speaking, that act of speaking, okay, the things speak for itself. So from the circumstances, okay, you can say that, well, so it's a case of circumstantial evidence, okay. So from the circumstances, you can assume that, well, something has happened. So the thing speak for itself, okay, as you have said, res ipsa loquitur, okay. So two requirements are there for the application of this maxim. The first one is the injurious agency was under the management or control of the defendant. So the plaintiff says that, well, the defendant is responsible, okay. So in such case, the defendant here was managing or was under the control of the agency, the object that caused the injury, okay. That's the first requirement, okay. And secondly, the accident is such as in ordinary course of things does not happen if those who have the management use proper care. So we all know that, well, such an accident is just not possible had it not been for the lack of care on the part of the management. If the management had exercised ordinary care, okay, proper care, then such incident would not happen in the ordinary course, okay. So if these two elements are there, then you can say that, well, the burden of proof here, so it does not prove conclusively anything. It merely shifts the burden of proof, okay. It merely shifts the burden of proof from the plaintiff, who is to prove negligence, now on to the defendant, who is to now prove that, well, it was not due to his negligence. So I will share one very important case first by the name, I know how it's pronounced, Byrne versus Bodle, I think that's how it is pronounced. So if you just go to this link, okay, you will find the case, okay. So just click on it, jump to the facts of the case. You see, the defendant's shop was adjacent to the road, okay. The defendant's shop was adjacent to the road on which plaintiff was walking, and the barrel appeared to have fallen or was dropped from the shop. So while the plaintiff was walking, a barrel comes, hits the plaintiff, and from the incident, it seemed that it was dropped, okay. It had fallen or dropped from the shop, okay. So the issue was the mere fact that the incident occurring, that is the barrel having fallen from the shop, sufficient to presume negligence, okay, on the part of defendant? It was held that the court allowed the case to proceed because of the nature of the harm-causing event and defendant's relationship to it. Remember those two incidents that we discussed. As it was defendant's responsibility to control the content of his warehouse, the accident itself is evidence of negligence, okay. So it's an evidence of negligence, okay. It does not conclusively prove anything. Now the defendant will have the opportunity to disprove it, okay. So it's a rule of evidence, okay. It shifts the burden from the plaintiff to prove that the defendant is negligent to that of the defendant now to disprove that, okay, he or she was negligent, okay. So look at the discussion. It says a plaintiff seeking to rely on res ipsa loquitur must connect the defendant to the harm, okay. So it's clearly established here. Initially, courts interpreted the control element narrowly, requiring the plaintiff to show that the defendant likely had exclusive control over the harm-causing instrumentality. This element has been liberalized, and it is now enough for plaintiff to get the issue to an injury on res ipsa loquitur if he can provide evidence showing that the defendant probably was the responsible party, even if the defendant did not have exclusive control. So anyway, those are not that important. You see that the two elements that we have just discussed, those are the requirement. Okay, so what are those? that the injury causing agency was under the management and control of the defendant. Okay, the accident is something that does not happen in the ordinary course of nature. Okay, had it not been for those who were in charge, okay, of the injurious agency, had they exercised proper care. So if these two elements are there, then the assumption is that the defendant was liable. But the defendant will have the opportunity to now prove that the defendant was not liable. Another very important case, as I told you, is by the name Municipal Corporation of Delhi versus Subhagwanti. So, see, I don't know, I wouldn't share these links, but it's okay, fine. I mean, I've checked it. So, just look at, the facts here in the link that I have shared. Okay. So, you see brief facts and procedural history. Okay. 3 suits for damages were filed by the respondents. Okay, as heirs to the 3 persons who died. Okay, from what? There was a clock tower in Chandni Chowk, okay, that belonged to the appellant corporation, that is Municipal Corporation of Delhi, and as a result of collapse of that clock tower, okay, this heirs of the respondents had died. No, sorry, the respondents had died. Okay. The building was quite old. It was 80 years old. Okay, and as it seems, okay, the building had lost its structural integrity. Okay, so the life of the structure of the top story, having regard to the type of the mortar used, could have lasted for 40-45 years. Okay, and the middle story could be saved for another 10 years. Given the fact that it was in its 80th year. Okay. So from that, it seems that the defendant had not taken adequate care. Okay, so the collapse of the clock tower was due to the thrust of the arches on the top portion. If an expert had examined the building specifically for the purpose, he might have found out that it was likely to fall. When the building was in fact inspected after the collapse, it was found that it had deteriorated to such an extent that it was reduced to powder without any cementing properties. So for the court, it was to decide whether the doctrine of res ipsa loquitur would apply. And in this particular case, it was in fact held that the doctrine of res ipsa loquitur would in fact apply. So yeah, go through the rest of it, in details if you want to, but this is how the maxim, this is how the doctrine works. Okay, so are you guys with me till now? Do I make sense?
Yes, sir.
Okay, any difficulties in understanding anything so far? Okay, then I would assume that you have understood. Are you guys there? Because I don't hear anything, just 1 or 2 students.
Yes, sir.
You guys are there?
Yes, sir.
Okay.
Yes, sir.
So don't do this, okay? Be there while we have discussion, okay? You guys are
Excuse
not...
me, sir.
Yes.
Sir, I have a doubt, but a small doubt, sir. Can you clarify, please?
Yes, definitely.
On contributory negligence, sir.
Yes.
Actually, you have discussed, but I cannot clear with.
Which
Sir,
one?
I have a doubt that if both parties are wrong, but one party doesn't contribute in negligence, is the remedy available to the plaintiff, like sir, if a bus coming at a high speed on the wrong side of the road hit a driver of an overloaded rickshaw going to a correct side, is a contributory negligence?
See,
A bus driver is also wrong.
I understood what you said. See, it's a very good question that you have asked, okay? Now the thing is, suppose this other car that you have mentioned was overloaded, okay? But was the fact that it was overloaded in any way contributed to the, ultimate accident? If it wasn't...
No, sir.
So, no, that's the question, okay? If it did not contribute, then obviously, that will not be a factor. Maybe that car would be held liable under other laws, laws, regulations that regulate how much weight is to be carried. Okay, but that's a different issue. Now, if the accident here did not happen because of that, but because of the negligence on the part of the other car driver, then obviously it will not be a case of contributory negligence on the part of the party here who had overloaded. Do you understand?
Sir, it means, sir, we have to not wrong. It also contribute in the.
Yes, that's why it is contributory negligence. Your action should contribute to the ultimate, incident that has happened.
Okay, sir.
Okay.
Thank you.
So it's very simple, and it's a very good question that you have asked. Okay. So it is contributory negligence because the act, involved a lack of exercise of ordinary care, skill, judgment, that led to the accident. But the said, fault did not contribute. If it did not contribute to the, act, to the, incident, then obviously that will not be a case of contributory negligence. Okay. So I hope you got the point here. Both the, act here should relate to the incident that happens. Okay. So I told you at the very beginning that, people could be wrong in many other ways, but those would not be reason for holding them to be contributory negligent unless those wrongs, committed by them, in fact, contributed to the, negligence leading to the accident. So this is a very good question that you have asked. Okay. So thank you. So that's it. That's all about contributory negligence. Okay, so with respect, so that's there. Okay, negligence is almost over. So and then in this, I think module we have one more. Okay, very important topic. I think it's just a second. Let me check. Yes, it's on the topic of. Vicarious liability. Okay, and then we have another topic of nuisance. I don't know how much of it will be completed, but I'll complete these two topics definitely. Then I'll complete at least 2-3 very important topics from the next module, and at least introduce Motor Vehicles Act as much as possible. So yeah, bear with me. So let me introduce the next topic so that tomorrow we are able to complete that, and if possible even nuisance. So the next important topic is vicarious liability. Okay, it's a very important topic. Okay, so generally, as you know, it's very commonsensical understanding. Okay, that you will be held responsible for the wrongful act that you have committed. Okay, or wrongful omission on your part. Okay, generally you will be held responsible for your own wrong. Okay, a person is to be held liable for their own wrong. Okay, one is, it seems very unfair, that you are held liable for the wrong committed by someone else. Okay, and then you'll be like, how the hell is that justifiable? How the hell is that acceptable? That I am held for a wrong that I have not committed, but have been committed by someone else. Okay, so that's what law of tort is essentially based on. Law of tort holds you responsible for the wrongs that you commit. Okay, so that's the generally accepted rule, but there is an exception. Okay, when one is held for the wrongful acts of another. Okay, and that's the case of vicarious liability. Now this is not without its justification. Okay, otherwise we would say that, well, that's nonsense, that's ridiculous. But then there is a justification for that. Okay, and this is an exception to the general rule that one is to be held liable for his or her own wrongful acts or omissions. Okay, so the exception is vicarious liability, which says that there are certain situations, there are certain limited situations, not in all situations, certain situations when one can be held responsible for the act of another. And that's the case of vicarious liability. So liability that is based not on a person's own wrongdoing, but rather on the person's relationship to the wrongdoer. Okay, so here a person is held responsible not for his or her own wrongdoing, but the wrong that has been done by another, but this person stands in a special relationship with the actual wrongdoer. Okay, and that's when you have this exception to this rule, and then that's known as the principle of, the rule of vicarious liability. Okay, now these emerge in certain very specific relationships. Okay, and we are going to discuss two which are very important for us. Okay, and to a certain extent, I mean, it's understandable. Okay, so what are those? Is the case of principal and agent. Okay, the relationship between principal and agent, and then there is a master servant relationship. And when it comes to partnership, okay, the partners are also held responsible for the torts of other partners. Okay, so in those cases, okay, now partnership is a very is a kind of different matter. But for us, the more important would be the principal-agent relationship and the master-servant relationship. Now, this is based on certain maxims and certain social policies. Okay, so there are reasons for why this is the case. Okay, why one is responsible for held responsible for the acts of another. So you need to remember this maxims. Okay, the first one is qui facit par eliam facit per se. Okay, I'll just share it here with you guys. Just a second. Okay, qui facit par eliam facit per se. It means he who does an act through another does it himself. Okay, so if you do an act through another, okay, something that you would do for yourself, okay, but you got it done through another, okay, law would assume that you have done it yourself. Okay, because you have authorized the other person, okay, to do the act. So the person who has authorized would be held liable. Okay, not only for the tort that you have authorized, okay, but also for other direct consequences of that tortuous act which has been committed by that person. Okay, so what is the maxim? The maxim is qui facit par eliam facit per se. It means he who does an act through another does it himself. Okay, and there is another one that is by the name respondeat superior. Just a second. Okay, as you can see it there, respondeat superior. So essentially in the case of master-servant relationship, okay, the master is held responsible for every wrong, okay, every wrong which is committed by the servant, okay, or in the course of the service, in the course of the employment, even though the master did not command the did not ask the servant, okay, expressly to do such tortuous act. Okay, so one need not prove that the master had given the express command to the servant to do such tortuous act. Okay, but if it is something which is done by the servant in the course of the service or employment, then the master will be held liable. Hence the rule of respondeat superior. The superior is held responsible for the actions, for the wrongful actions of the one who was in who was in his charge. Okay, who was acting on behalf of the superior. Now, apart from this, okay, these are not the only reasons. Okay, these are two maxims that help you in understanding, but there are rules of practical, okay, expediency. Okay, there are certain social requirements, certain policy considerations, okay, that also play a part. Okay, so here's why. Okay, you know that the principal, okay, or the master quite often has all the resources. Okay, they are usually companies, corporations with lots of money, resources. Okay, whereas the person who has been employed, the servant, not so much. Okay, so if the party who has suffered, okay, is to approach only as against the servant, it's not very likely that he or she would be adequately compensated. So it makes sense as a matter of expediency, okay, that the said person be also allowed to go against the person who had employed the master, okay, or the principal. Okay, so that is very important. Okay, so And then apart from that, okay, usually because these are, okay, companies, corporations, okay, they also insure themselves, okay, there are so many insurances that they take up, okay, so they can distribute the loss, that they suffer, okay, so they can increase the price of the product, okay, and there are so many ways for them to distribute the loss that they suffer, okay, so it seems it makes more sense that even the this sorry even the superior here, okay, is allowed to be uh, to be made a party here, okay, so that's essentially what this idea is all about, okay, so I hope you guys are with me so far. Do you guys understand what this idea of vicarious liability is all about?
Yes, sir.
Yes, sir.
Okay,
Yes, sir.
so it arises only in those cases of special relationships, okay, so that would be master servant relationship or principal agent relationship, and even in case of partnership, okay, the partners are held liable for one another's tort, okay, so these are also known as the cases of um, joint liability, okay, we'll discuss that later on, okay, so if in such case, who can you go against, okay, who do you go against? I mean, you can obviously go against the choice is up to you. You can go against the servant who has committed, okay, the wrong, but you are also not precluded from going as against the master, okay, or you can make both of them party to the suit, okay, so that's what the idea of vicarious liability is, okay, so tomorrow we will discuss what is a master servant relationship, okay, and then, yes.
Sir, I have a question.
Yes.